The call came on December 27th while I was reviewing case files in my apartment, still recovering from a Christmas I had spent alone for the first time in my adult life. "Mom calling," the screen said. I answered. "Hi, Mom." "Sarah, honey, Richard and I need to talk to you about New Year's Eve." My stomach dropped. I knew that tone. Careful, diplomatic. The voice she used when delivering bad news disguised as reasonable planning. "What about New Year's Eve?" I asked. "Well, Richard is hosting a party at the house. Several federal judges and their families, prominent attorneys, very important people, and we think it might be best if you sat this one out." "Sat it out," I repeated. "Given your work, honey, class action lawsuits, plaintiff side, advocacy. Richard's circles can be quite conservative about those things. You understand?" "Richard, my stepfather of 8 months, the Honorable Richard Whitfield, Federal District Court Judge for the Western District." I asked if she was uninviting me from New Year's Eve because my job embarrassed him. "It's not about embarrassment, Sarah. It's about maintaining appropriate professional boundaries. Richard has a reputation to uphold." I pointed out that I was his stepdaughter, not his employee. "And he respects that," she said. "But he also has responsibilities to the federal bench. Surely you understand." I understood perfectly. I just didn't expect my own mother to side with a man who had decided her daughter wasn't good enough for his New Year's Eve party. What I didn't know was that in exactly 3 weeks, Richard Whitfield would see my name on his court docket and realize that keeping me away from his celebration was the least of his problems. "My name is Sarah Mitchell. I'm 34 years old, and I'm a senior associate at Brennan & Cole, a plaintiff-side litigation firm in Seattle. I specialize in class action lawsuits, which means I represent groups of people who have been harmed by corporations, pharmaceutical companies, or other large entities that put profits over people. It's not glamorous work in the way that corporate law or white-collar defense can be. I don't represent Fortune 500 companies or negotiate billion-dollar mergers. I represent ordinary people who got hurt, who lost money, who were lied to by companies that should have protected them. My mother has never really understood what I do. She knows I'm a lawyer, which sounds impressive at cocktail parties, but she doesn't quite grasp the difference between representing a pharmaceutical company and suing one. To her, lawyers are lawyers, and the specifics don't matter as much as the prestige. Richard Whitfield, on the other hand, understood exactly what I did, and he hated it. Richard had been appointed to the federal bench 3 years ago after a long career in corporate defense litigation. He had spent 25 years representing insurance companies, manufacturers, and pharmaceutical corporations against exactly the kind of lawsuits I filed. He had made partner at one of Seattle's most prestigious firms by defending companies against claims of negligence, fraud, and corporate malfeasance. His judicial philosophy, as he liked to explain at dinner parties, was grounded in protecting businesses from frivolous litigation and preventing the legal system from being weaponized by trial lawyers seeking massive settlements. In other words, people like me were everything he stood against. My mother had met Richard at a charity gala 18 months ago. She was a widow. My father had died of a heart attack when I was 28, and she had been lonely. Richard was recently divorced from his first wife, distinguished, well-connected, and attentive in a way that made my mother feel special. They married 8 months ago in a small ceremony at Richard's estate in Bellevue. I was invited, though Richard made it clear through careful word choice that he would have preferred a more private affair. The guest list included several federal judges, a state Supreme Court justice, and various attorneys from Richard's former firm. I attended because my mother wanted me there. I wore an appropriate dress, made polite conversation, and left early to avoid any awkward discussions about my work. Since the wedding, I had seen my mother exactly 3 times, twice for brief lunches where she talked mostly about Richard's social calendar, and once for a tense dinner at their house where Richard spent the evening explaining to his colleagues why tort reform was essential to protecting American business. I had not been invited to Thanksgiving. Richard was hosting a dinner for several judges from his circuit, and my mother had called 2 weeks before to explain that it might be awkward given my professional focus. I had spent Thanksgiving with friends, pretending it didn't bother me that my own mother had chosen her new husband's comfort over her daughter's presence. And now, Apparently, I wasn't welcome at New Year's Eve either. I asked my mother who would be attending Richard's party. She listed names I recognized from legal publications and news coverage. Judge Harold Chen from the Ninth Circuit Court of Appeals, Judge Margaret Stinson, who had recently been appointed to the Federal District Court in Oregon, several attorneys from Morrison and Hayes, the firm where Richard had been a partner before his judicial appointment, a state senator who sat on the Judiciary Committee, the dean of the University of Washington Law School. It was Richard's professional world, the network of influential people he had cultivated over 30 years in corporate law and 3 years on the federal bench, a world where connections mattered more than principles, where reputation was currency, and where someone like me, who sued the corporations these people had spent their careers protecting, was seen as a threat to the natural order. My mother said the party would start at 8, champagne and hors d'oeuvres in the Grand Salon, followed by dinner at 9:30. A string quartet had been hired. The caterer was the same one who had served at a reception for the State Bar Association. Everything was planned to impress, to remind Richard's guests that he had arrived, that he belonged in their world. And I would be conspicuously absent. I asked my mother if she understood what she was asking me to accept. She was quiet for a moment. Then she said that sometimes we have to make sacrifices for the people we love, that Richard's career was important, that his reputation mattered, and that my presence might create uncomfortable conversations that could damage his standing with his colleagues. I told her I understood. I didn't argue. I didn't try to change her mind.
I just said I hoped she enjoyed the party and ended the call.
I spent that evening wondering when exactly I had become someone my mother was ashamed of. I had graduated third in my law school class. I had clerked for a state appellate judge. I had built a reputation as a skilled litigator who won cases and secured meaningful settlements for clients who had nowhere else to turn. But in Richard Whitfield's world, that made me an enemy, a plaintiff's attorney, someone who threatened the natural order of things by holding powerful companies accountable for their actions. And my mother, who had once been proud of my work, now saw me through his eyes. I didn't cry about it. I had learned a long time ago that tears didn't change anything. Instead, I opened a bottle of wine, ordered takeout, and spent the rest of the evening reviewing the preliminary research for a case I had been developing for the past 6 months. The case involved Veritas Pharmaceuticals, a mid-sized drug manufacturer that had released a diabetes medication called glucosamine 3 years ago. The drug had been fast-tracked through FDA approval based on clinical trials that showed promising results for blood sugar control with minimal side effects, except the clinical trials had been incomplete. Veritas had cut corners in their testing, focusing on short-term efficacy while ignoring early warning signs of serious long-term complications. Within 18 months of glucosamine's release, reports started emerging of patients developing severe liver damage, kidney failure, and in some cases, complete organ shutdown. Veritas had known about these risks. Internal emails obtained through discovery in earlier cases showed that company scientists had flagged potential toxicity issues during the trial phase, but executives had decided to proceed with FDA submission anyway, gambling that the problems wouldn't emerge until after the drug was already generating revenue. By the time the FDA issued warnings and Veritas pulled glucosamine from the market, 12,000 patients had been prescribed the medication. 400 had developed serious complications. 23 had died. I had spent 6 months working with a team of medical experts, reviewing clinical data and interviewing patients who had been harmed by glucosamine. We had filed a class action lawsuit on behalf of nearly 8,000 plaintiffs, seeking compensation for medical expenses, pain and suffering, and punitive damages based on Veritas's knowing concealment of safety risks. The internal documents we had obtained during the discovery process were damning. There was an email from Dr. Helena Ross, Veritas's lead toxicologist, sent to the chief scientific officer 14 months before FDA approval. The email detailed her concerns about elevated liver enzyme levels in test subjects during phase 2 trials. She had recommended extending the trial period to monitor long-term effects. The chief scientific officer had responded that extending trials would delay their timeline for FDA submission and cost the company an additional $8 million in development expenses. He had suggested that Dr. Ross focus on the positive results and downplay the liver enzyme findings as within acceptable variation ranges. There was another email chain between marketing executives discussing how to position glucosamine once safety concerns started emerging. One executive had written that they should emphasize the drug's benefits for blood sugar control while characterizing liver issues as rare side effects that occurred in patients with pre-existing conditions. Another had suggested creating patient education materials that mentioned liver monitoring as a routine precaution rather than a response to known risks. The most damning document was a memo from the CEO, Dr. Marcus Brennan, to the board of directors. The memo acknowledged that Veritas was aware of potential organ toxicity, but argued that the financial opportunity was too significant to delay. Glucosamine had the potential to generate $300 million in annual revenue. If they pulled the drug or extended testing, a competitor would likely beat them to market with a similar medication. Dr. Brennan had written that some level of adverse events was inevitable with any pharmaceutical product. The key was managing the public relations response and ensuring that Veritas maintained plausible deniability about the extent of their knowledge regarding safety risks. That memo had been written 6 months before FDA approval, 6 months before 12,000 patients started taking a drug their doctors assured them was safe, 6 months before people started dying. Our case was built on these documents, on testimony from Veritas employees who had raised concerns and been ignored, and on medical evidence showing a clear causal link between glucosamine and the organ damage our clients had suffered. But we needed a fair trial. We needed a judge who would evaluate the evidence impartially and allow the jury to see the full scope of Veritas's misconduct. What we got instead was a random assignment that threatened to turn the trial into a referendum on my relationship with my stepfather. On December 31st, while I sat alone in my apartment eating leftover Chinese food and watching the countdown on television, Richard's New Year's Eve party was in full swing. I learned the details later from my mother, who described the evening with a mixture of pride and guilt. The house had been decorated with white roses and silver accents. The string quartet had played Vivaldi and Mozart in the grand salon, while guests sipped Dom Perignon and sampled canapés prepared by a chef who had trained in Paris. Richard had given a toast at 11:30, thanking his colleagues for their friendship and support, praising the federal judiciary as the last bastion of rational decision-making in an increasingly polarized world. Judge Chen had responded with his own toast, welcoming Richard to the brotherhood of federal jurists and expressing confidence that Richard would continue to uphold the traditions of judicial restraint and respect for precedent that defined their court. At midnight, champagne glasses were raised, fireworks were visible through the floor-to-ceiling windows overlooking Lake Washington, and Richard kissed my mother while his colleagues applauded. It was everything Richard had wanted, a celebration of his status, his connections, his arrival in the world of federal judges who shaped American law, and I had not been there to see it. My mother told me about the party 2 weeks later during one of our stilted phone calls. She described the decorations, the food, the guests. She mentioned that several people had asked about me and that she had explained I was busy with work. I asked if anyone had seemed surprised by my absence. She admitted that a few people had looked uncomfortable when she mentioned my work. One judge had asked if I was the Sarah Mitchell who had filed the Veritas case. My mother had confirmed it, and the judge had made a comment about plaintiff attorneys being necessary even if they were unpleasant. Richard had laughed and said something about how even families couldn't escape the adversarial nature of the legal profession. My mother had smiled and changed the subject. She told me this as if it were amusing, as if Richard's casual dismissal of my career in front of his colleagues was just good-natured banter. I said nothing. There was nothing to say that wouldn't damage our relationship further. But I remembered that conversation 3 weeks later when everything changed.
The case assignment came on January.
I was in a meeting with my litigation team when my paralegal knocked on the conference room door. "Sarah, you need to see this," she said, holding up her laptop. I excused myself and followed her to her desk. She pulled up the federal court's electronic filing system and showed me the notification that had just come through. Case number 224 CV 03847, Mitchell et al. V. Veritas Pharmaceuticals Inc., assigned to the Honorable Richard M. Whitfield, United States District Judge. I stared at the screen, reading the assignment 3 times to make sure I wasn't misunderstanding. My case, the biggest case of my career, representing 8,000 plaintiffs against a pharmaceutical company that had killed people with a drug they knew was dangerous, had been randomly assigned to my stepfather. The odds of this happening were astronomical. The Western District had 15 active federal judges. The random assignment system was designed to distribute cases evenly among them to prevent judge shopping or preferential treatment. And somehow, out of 15 judges, my case had landed on Richard Whitfield's docket. My paralegal was looking at me with concern. "Is this going to be a problem?" she asked. I told her I needed to make some calls and went back to my office. The first thing I did was pull up Richard's campaign finance records. Federal judges are appointed, not elected, but before their appointment, many of them are active in political and legal circles, attending fundraisers and building relationships with senators who will eventually confirm them.
Richard had been no exception. Before his appointment to the bench, he had run a campaign to position himself as a candidate for judicial nomination. That campaign had required funding events, publicity, networking with influential people who could recommend him to the senators who would vote on his confirmation.
I spent 2 hours reviewing public records from the Federal Election Commission and Washington State's campaign disclosure database. The records showed dozens of donations from attorneys, law firms, and business executives who had worked with Richard during his career in corporate defense. And there, in the middle of the donor list, was a name that made my blood run cold. Dr. Marcus Brennan, Chief Executive Officer of Veritas Pharmaceuticals, Occupation Pharmaceutical Executive, donation amount $50,000, date October 15th, 4 years ago.
$50,000.
The maximum allowable contribution under federal campaign finance law. I pulled up Dr. Brennan's biography on the Veritas website. Before becoming CEO, he had spent 15 years in pharmaceutical development and regulatory affairs. Before that, he had worked as a consultant advising drug manufacturers on FDA approval strategies and litigation risk management. I cross-referenced his name with Richard's former law firm. Morrison and Hayes had represented Veritas in separate product liability cases between 2012 and 2017. Richard had been the lead attorney on 2 of those cases. Richard and Dr. Brennan had a professional relationship that stretched back over a decade. They had worked together defending Veritas against lawsuits. Dr. Brennan had then donated the maximum legal amount to support Richard's judicial appointment. And now Richard was assigned to preside over a case in which Dr. Brennan's company was the defendant. This wasn't just a conflict of interest. This was a textbook example of why recusal rules existed. Federal law requires judges to recuse themselves from cases where their impartiality might reasonably be questioned. That includes cases involving parties who have made significant financial contributions to the judge's campaigns, cases involving family members, and cases where the judge has any personal or financial interest in the outcome. Richard should have recused himself the moment he saw my name as lead counsel. The fact that I was his stepdaughter created an obvious appearance of bias. Add in the $50,000 donation from the defendant's CEO, combined with Richard's prior professional relationship with Veritas, and recusal wasn't just appropriate, it was mandatory. But Richard hadn't recused himself. The case was still on his docket. I called my senior partner, Thomas Brennan, no relation to the Veritas CEO, despite the coincidental surname. Tom had been practicing law for 35 years and had seen every variety of judicial misconduct, ethical violation, and courtroom impropriety imaginable. I explained the situation, the random assignment, the family relationship, the campaign donation, the prior professional relationship between Richard and Veritas. Tom was quiet for a moment, Then he said we needed to file a motion for recusal immediately. I asked if we should try to handle this privately first. Maybe call Richard's clerk and explain the situation. Tom said absolutely not. Conflicts like this needed to be on the record. If we tried to handle it quietly and Richard refused to recuse himself, we would have no documentation of our objection. Everything needed to be formal, filed with the court, part of the public record. We spent the next 3 hours drafting a motion for recusal. The document laid out 3 clear grounds. First, that I was Richard's stepdaughter, creating a family relationship that could reasonably call his impartiality into question. Second, that the defendant's CEO had made a substantial financial contribution to Richard's judicial campaign. And third, that Richard had previously represented Veritas in his capacity as a defense attorney, creating a prior professional relationship with the defendant. We cited relevant case law, federal recusal statutes, and judicial ethics guidelines. We attached evidence of the campaign to Nenin pulled from public records. We documented Richard's prior work for Veritas through court filings and firm records. We requested that Richard voluntarily recuse himself and allow the case to be reassigned to another judge. The motion was filed on January 8th, 2 days after the case assignment. Under court rules, Richard had 14 days to respond. The response came in 7. I was reviewing deposition transcripts when my paralegal knocked on my door again. She looked shaken. Judge Whitfield's chambers just filed a response to your recusal motion, she said. I pulled it up on my computer. The response was 6 pages long. In it, Richard acknowledged the family relationship, but argued that it did not create any actual bias or appearance of impropriety. He noted that his relationship with me was cordial but not close, that we had limited contact since his marriage to my mother, and that his professional obligation to impartiality outweighed any personal considerations. Regarding the campaign donation, Richard argued that it had been made 4 years ago during a campaign that had involved dozens of major donors. He stated that he had no ongoing relationship with Dr. Brennan beyond occasional professional interactions at industry events. A single campaign contribution from one individual associated with a corporate defendant did not, in his view, create a sufficient conflict to warrant recusal. Regarding his prior representation of Veritas, Richard noted that his work for the company had concluded 7 years ago when he left Morrison and Hayes to pursue his judicial appointment. He argued that representing a client in a professional capacity does not create a permanent conflict that prevents a judge from hearing cases involving that client years later. The motion for recusal was denied. Richard Whitfield would be presiding over my case. I sat at my desk staring at the denial, trying to process what had just happened. Richard knew exactly what he was doing. By denying the recusal motion, he was gambling that I wouldn't tell it the issue. He was betting that I would accept his decision, proceed with the case, and avoid creating a public conflict that might embarrass him or damage his reputation. What he didn't understand was that I wasn't playing by his rules anymore. I called Tom again. We need to take this public, I said. Tom agreed. We would file an emergency petition with the Ninth Circuit Court of Appeals, asking them to review Richard's refusal to recuse himself. We would also send copies of our motion and Richard's denial to the Seattle Times, the illegal press, and every judicial ethics watchdog organization we could find. If Richard wanted to keep this quiet, he had made a serious miscalculation. The emergency petition was filed on January 16th. Unlike a standard recusal motion, which could take weeks to resolve, an emergency petition required the appellate court to act quickly. We argued that allowing Richard to preside over the case created an immediate and irreparable appearance of impropriety that would undermine public confidence in the judicial system. We also sent a carefully worded press release to several legal reporters explaining that a federal judge was refusing to recuse himself from a case involving his stepdaughter as lead counsel and a defendant whose CEO had donated $50,000 to his judicial campaign and whom he had previously represented in his private practice. The story broke on January. The headline in the Seattle Times read, "Federal Judge Faces Ethics Questions Over Refusal to Recuse in Stepdaughter's Case." The article detailed the basic facts: that I was lead counsel on a major pharmaceutical class action, that the case had been assigned to my stepfather, that the defendant's CEO had donated significantly to my stepfather's judicial campaign and had been a former client that my stepfather had refused to step aside despite the obvious conflicts. The article quoted several legal ethics experts. Professor Michael Chen from Stanford Law School said that Richard's refusal to recuse himself was highly unusual and appeared to violate the spirit, if not the letter, of federal judicial conduct standards. He noted that the combination of a family relationship, a major campaign contribution, and a prior attorney-client relationship created multiple overlapping conflicts that should have made recusal automatic.
Professor Angela Morrison from Georgetown Law said that even if Richard believed he could be impartial, the appearance of bias was so strong that his continued involvement in the case would undermine public trust in the judicial system. She noted that recusal rules exist not just to prevent actual bias, but to ensure that the public has confidence in the fairness of judicial proceedings.
The article also included a statement from Richard's chambers, which said that Judge Whitfield stood by his decision and that his impartiality was beyond question. By the afternoon, the story had been picked up by Law 360, Above the Law, and several national legal publications. Legal Twitter was filled with commentary from attorneys and law professors, expressing shock at Richard's refusal to recuse himself. By the next morning, the story was being discussed on courthouse steps across the country and had been mentioned in a legal ethics column in the Washington Post. The public pressure was immediate and intense. My phone started ringing with calls from reporters asking for comment. I issued a brief statement saying that I had confidence in the appellate process and that I believed the Ninth Circuit would make the right decision. Richard's chambers issued a longer statement defending his reasoning and suggesting that my recusal motion was a strategic attempt to delay the proceedings and obtain a more favorable judge. The statement backfired spectacularly. Several legal commentators pointed out that suggesting a plaintiff's attorney would file a recusal motion for strategic advantage rather than legitimate ethical concerns was itself evidence of bias against the plaintiff. The Ninth Circuit scheduled oral arguments on our emergency petition for January 22nd, just 4 days after the petition was filed. I didn't attend the arguments. Tom handled them since I was a party to the dispute, but I listened to the audio recording later that day. The three-judge panel asked pointed questions about Richard's reasoning. Judge Elizabeth Nakamura asked why Richard had concluded that a $50,000 donation from a defendant's CEO didn't create an appearance of bias. She noted that $50,000 was the maximum allowable contribution, which suggested a significant level of financial support. Judge Robert Williams asked why Richard had determined that presiding over his stepdaughter's case was appropriate when federal recusal statutes explicitly mention family relationships as grounds for recusal. Judge Sandra Martinez asked what message Richard's refusal to recuse sent about judicial independence and public confidence in the courts. Richard's attorney, representing him in the appellate proceeding, struggled to provide satisfactory answers. He argued that Richard had carefully considered the issues and had determined in good faith that he could be impartial. He suggested that requiring recusal in every case involving a remote family connection or a campaign donor would make it impossible for judges to hear cases. Judge Nakamura responded that a stepdaughter was not a remote family connection, and that a $50,000 contribution from a defendant's CEO whom the judge had previously represented was not a minor donor relationship. The panel's decision came down on January 20th. The Ninth Circuit granted our petition and ordered Richard to recuse himself immediately. The opinion was 11 pages long and scathing. The court noted that Richard's refusal to step aside had created a clear appearance of impropriety that threatened public confidence in the judicial process. The opinion stated that while judges are presumed to be capable of impartiality, that presumption cannot override the appearance of bias created by multiple overlapping conflicts. The court specifically noted that the combination of a family relationship with lead counsel, a substantial campaign contribution from the defendant's CEO, and a prior attorney-client relationship with the defendant created a situation where no reasonable observer could have confidence in the judge's impartiality. The case was reassigned to Judge Patricia Morrison, a widely respected jurist with no connections to any party in the litigation. Richard Whitfield had been publicly rebuked by the appellate court. His judgment had been questioned, his ethicists, and his decision-making authority overridden. But the story didn't end there. Once the recusal became public, reporters started digging into Richard's past rulings. What they found was troubling. Over the past 3 years, Richard had presided over 11 cases involving companies or individuals who had donated to his judicial campaign. In 9 of those 11 cases, he had ruled in favor of the donor. A Seattle Times investigative reporter named Jennifer Park spent 2 weeks analyzing Richard's docket and cross-referencing it with campaign finance records. Her findings were published on January 28th under the headline, "Pattern of Favoritism. Federal Judges' Rulings Favor Campaign Donors." The article detailed each of the cases. In one, Richard had dismissed a wrongful termination lawsuit against a technology company whose CEO had donated $25,000 to Richard's campaign. The plaintiff had appealed, and the Ninth Circuit had reversed Richard's dismissal, finding that he had applied an overly restrictive standard that contradicted established employment law. In another case, Richard had granted summary judgment in favor of an insurance company in a bad faith denial claim. The insurance company's president had donated $15,000 to Richard's campaign. The plaintiff had settled rather than appeal, but the terms of Richard's ruling had been criticized by plaintiff attorneys as unusually favorable to the insurance company. In a third case, Richard had ruled that a pharmaceutical company's warning labels were adequate despite evidence that patients had suffered severe allergic reactions to a medication. The pharmaceutical company's chief counsel had hosted a fundraiser for Richard's judicial campaign that had raised over $40,000 from attendees in the pharmaceutical industry. The pattern was undeniable. When parties who had financially supported Richard's appointment came before his court, they won at a significantly higher rate than parties who hadn't supported him. The article quoted legal ethics experts who said the pattern suggested potential bias, whether conscious or unconscious. Professor Chen from Stanford said that while any individual case might have been decided correctly on the merits, the cumulative pattern raised serious questions about whether Richard was capable of setting aside his relationships with donors when evaluating cases. The article called for a formal investigation by the judicial conduct authorities. The federal judiciary doesn't like scandals. Judges are supposed to be above reproach, impartial arbiters of the law who make decisions based on facts and legal principles, not political favors or financial relationships. When a judge's conduct creates the appearance of bias, it threatens the legitimacy of the entire system. On February 2nd, the Judicial Council for the Ninth Circuit announced that it was opening a formal investigation into Richard Whitfield's conduct. The investigation would examine whether his refusal to recuse himself in my case, combined with the pattern of favorable rulings for campaign donors, violated federal judicial conduct standards. Richard tried to downplay the investigation, issuing a statement through his attorney saying he was confident that the review would vindicate his record. He characterized the investigation as a routine matter prompted by media attention rather than actual misconduct.
But the legal community wasn't convinced.
Several prominent attorneys who had appeared before Richard started coming forward with their own stories. Attorney David Chen described a case where Richard had ruled against his client in favor of a technology company whose executives had attended a fundraiser for Richard's campaign. Chen said he had noticed at the time that Richard seemed unusually deferential to the defense counsel, who was a former colleague from Morrison and Hayes. Attorney Rebecca Singh described a case where Richard had dismissed her client's consumer protection lawsuit against a manufacturer whose CEO had donated to Richard's campaign. Singh said Richard had applied a legal standard that seemed inconsistent with Ninth Circuit precedent, but her client couldn't afford to appeal. Attorney Marcus Thompson described a products liability case where Richard had excluded critical expert testimony in a way that effectively gutted the plaintiff's case. The defendant was a company that Richard had represented during his time at Morrison and Hayes. Thompson said he had considered filing a recusal motion, but had been advised by senior partners at his firm that challenging a federal judge's impartiality could damage his reputation and make it harder to practice before that judge in future cases. These stories painted a picture of a judge who had never truly separated his previous career as a corporate defense attorney from his role as an impartial arbiter. Richard had maintained relationships with former clients and colleagues, accepted their financial support during his campaign for appointment, and then presided over cases in which those same individuals and companies appeared before him. The investigation expanded. What had started as a review of one recusal decision became an examination of Richard's entire judicial record. By March, the Judicial Council had interviewed over 40 attorneys, reviewed hundreds of case files, and subpoenaed campaigns records and communications between Richard and various donors. The investigation also uncovered something else. Richard had attended at least 6 social events hosted by individuals or companies who later appeared before him as parties in litigation. These weren't formal legal events or bar association gatherings. They were private dinner parties, golf outings, and charity galas where Richard socialized with the same corporate executives and defense attorneys whose cases he was supposed to be judging impartially. One of these events had been a private dinner at Dr. Brennan's home in 2021, 2 years after Richard's appointment to the bench. The dinner had been attended by several pharmaceutical executives and defense attorneys who specialized in FDA litigation. Richard had given an informal talk about trends in federal litigation and regulatory compliance. Dr. Brennan had later filed documents with the court in an unrelated case, and those documents had included a photograph from the dinner showing Richard and Dr. Brennan laughing together over drinks. The optics were terrible. Even if Richard's rulings had been legally correct, the appearance was that he was part of a social circle that benefited from his judicial decisions. On April 15th, the Judicial Council issued its findings. The report was 32 pages long and meticulously documented. It concluded that while there was no evidence of explicit quid pro quo corruption, no proof that Richard had made specific rulings in exchange for campaign contributions, there was substantial evidence that Richard had failed to maintain appropriate boundaries between his personal relationships and his judicial duties. The report noted that Richard had socialized extensively with attorneys and corporate executives who appeared before him in court. He had accepted campaign contributions from individuals who later became parties to litigation in his courtroom. He had ruled in favor of donors at a rate that significantly exceeded what would be expected by chance. Most critically, the report found that Richard's refusal to recuse himself from my case demonstrated a fundamental misunderstanding of judicial ethics. The report stated that a reasonable observer, aware of all the facts, could not have confidence that Richard would be impartial in a case involving his stepdaughter and a defendant whose CEO had donated $50,000 to Richard's campaign and whom Richard had previously represented. The Judicial Council recommended several sanctions. Richard would receive a formal reprimand that would become part of his permanent judicial record. He would be required to complete 20 hours of additional ethics training. And most significantly, he would be required to recuse himself from any future cases involving parties or attorneys who had contributed to his judicial campaign or had professional relationships with him prior to his appointment. Given the breadth of Richard's former practice and his extensive network of professional connections, this recommendation effectively gutted his docket. Over the next 2 months, Richard recused himself from 63 pending cases. His calendar, once filled with high-profile litigation involving major corporations and complex legal issues, became dominated by small claims disputes, routine motions, and cases that no one else wanted. Richard Whitfield, the prestigious federal judge who had once hosted New Year's Eve parties for his influential colleagues, became a judicial afterthought. The media coverage of the Judicial Council's findings was extensive. Legal publications ran articles analyzing the investigation and discussing what it meant for judicial ethics standards. Some commentators argued that the Council's findings were too harsh, that Richard had done nothing legally wrong and was being punished for the appearance of impropriety rather than actual misconduct. Others argued that the findings didn't go far enough, that Richard should have been removed from the bench entirely rather than simply reprimanded and restricted in his case assignments. My mother called me the day the findings were released. She was crying. She said Richard was devastated, that he felt the investigation had been a witch hunt driven by political opponents and vindictive attorneys, that he believed he had been punished for doing his job competently. I asked if he still believed he had done nothing wrong. She was quiet for a long moment, Then she said Richard maintained that his rulings had been legally correct and that the appearance of bias was being manufactured by people who disagreed with his judicial philosophy. I told my mother that judicial ethics weren't about whether rulings were legally correct. They were about whether the public could have confidence in the fairness of the process. A judge could make the right legal decision for the wrong reasons, and that would still be a violation of ethical standards. My mother said she understood, but that Richard was her husband and she had to support him. I said I understood too. We didn't talk again for 3 months. Meanwhile, my case against Veritas Pharmaceuticals proceeded under Judge Morrison's careful oversight. Judge Morrison was everything. Richard wasn't. Meticulous, impartial, and deeply committed to ensuring that both sides received a fair hearing. She granted appropriate discovery requests, ruled on motions based on legal merit rather than personal relationships, and made it clear that she would not tolerate any attempts to manipulate the proceedings.
The discovery phase of the case revealed even more damaging evidence than we had initially obtained.
Veritas's internal communications showed a pattern of prioritizing profit over patient safety that went beyond the glucosamine case. In email after email, executives dismissed safety concerns raised by their own scientists, characterizing adverse event reports as statistical noise that shouldn't interfere with marketing plans.
One particularly damning email chain involved a discussion about whether to disclose liver toxicity risks to the FDA during the approval process. Dr. Ross, the toxicologist, had recommended full disclosure along with a proposal for enhanced patient monitoring. The chief scientific officer had responded that full disclosure would likely trigger additional testing requirements that would delay approval by at least a year.
Dr. Brennan, the CEO, had weighed in with his own email. He had written that Veritas's investors were expecting glucosamine to launch within 6 months and that any delay would significantly impact the company's stock price and his own compensation package. He had suggested that they disclose the minimum information required by law and frame the liver enzyme findings as preliminary data that required further analysis.
The email included a line that would become central to our case: "We can't let perfect be the enemy of profitable." The single sentence captured everything wrong with Veritas's approach to patient safety. They had known their drug might cause serious harm, and they had decided that potential profits outweighed those risks. We also deposed several former Veritas employees who had left the company after raising safety concerns. Dr. Sarah Martinez, a clinical researcher who had worked on the glucosamine trials, testified that she had been pressured to minimize adverse event reporting. She described instances where patients in the clinical trials had experienced elevated liver enzymes, but she had been instructed to classify those events as unrelated to the medication unless there was definitive proof of causation. When Dr. Martinez had objected and said that standard research protocols required reporting all potential adverse events, her supervisor had told her that Veritas couldn't afford to have their FDA application derailed by excessive caution. She had been warned that if she insisted on including every minor abnormality in their safety reports, she would be replaced with someone who understood the business realities of pharmaceutical development. Dr. Martinez had ultimately resigned from Veritas 3 months before glucosamine received FDA approval. She had reported her concerns to the FDA, but her complaint had been one of hundreds the agency received each year, and it had not been given high priority during the review process. Another former employee, James Chen, who had worked in Veritas's pharmacovigilance department, testified about what happened after glucosamine was approved and adverse event reports started coming in from doctors and patients. Chen described a culture where reporting serious adverse events was discouraged. When doctors reported that patients were developing liver damage, Chen had been instructed to investigate whether those patients had other risk factors: alcohol use, pre-existing liver conditions, concurrent medications that could explain the damage without implicating glucosamine. Chen said he had been told explicitly by his supervisor that every adverse event report created potential legal liability and that the company's goal was to minimize the number of events that could be directly attributed to glucosamine. When Chen had compiled data showing that liver damage was occurring at rates far higher than would be expected by chance, he had been told to reformat his analysis to make the numbers less alarming. His supervisor had suggested breaking the data down into smaller subgroups to make the pattern less obvious. Chen had also ultimately resigned. He had kept copies of his reports and had provided them to our legal team during discovery. The picture that emerged from these depositions was clear. Veritas had known glucosamine was dangerous, had concealed that information from regulators, and had continued marketing the drug even after evidence of harm became undeniable. The case went to trial in June. The trial lasted 4 weeks. Judge Morrison's courtroom was packed every day with reporters, legal observers, and family member patients who had been harmed by glucosamine. Our opening statement focused on the human cost of Veritas's decisions. Tom began by introducing the jury to 3 of our clients. First was Robert Davidson, a 52-year-old accountant who had been prescribed glucosamine to manage his type 2 diabetes. Robert had been healthy before starting the medication, no history of liver problems, no alcohol abuse, no other risk factors. Within 6 months of taking glucosamine, he had developed severe liver damage that required a transplant. He had spent 8 months on the transplant waiting list, during which time his health had deteriorated to the point where he could no longer work. He had lost his job, depleted his savings, paying for medical care, and nearly died before a donor liver became available. Second was Jennifer Park, a 38-year-old teacher who had taken glucosamine for 14 months before developing acute kidney failure. Jennifer had been an active runner who competed in marathons. After glucosamine destroyed her kidney function, she required dialysis 3 times a week. Her running career was over. Her energy levels had plummeted. She could no longer work full-time or participate in the activities she loved. Third was Michael Chen, whose father had died from complications related to glucosamine-induced organ failure. Michael's father had been 63 years old, in good health except for his diabetes when his doctor prescribed glucosamine. Within a year, he had developed liver and kidney damage that progressed rapidly despite medical intervention. He had died in the hospital surrounded by his family. Less than 18 months after starting a medication his doctor had assured him was safe. Tom told the jury that what happened to Robert, Jennifer, and Michael's father was not an unavoidable medical tragedy. It was the predictable result of a pharmaceutical company's decision to prioritize profits over patient safety. Then Tom walked the jury through the evidence, the clinical trial data showing elevated liver enzymes. The emails where Veritas scientists raised concerns and were told to downplay them. The FDA submission that omitted critical safety information. The adverse event reports that came in after approval and were systematically minimized. The CEO's email saying that they couldn't let perfect be the enemy of profitable. Tom concluded by telling the jury that this case was about accountability, about holding a company responsible for putting a dangerous drug on the market when they knew it could kill people, about making sure that the next pharmaceutical company thought twice before cutting corners on safety testing. Veritas's defense was handled by a team from Morrison and Hayes, Richard's former firm. The lead attorney was Jonathan Price, a polished corporate defender who had spent 30 years protecting companies from exactly these kinds of claims. Price's opening statement focused on the complexity of pharmaceutical development and the inherent uncertainty in medical science. He argued that Veritas had conducted extensive clinical trials that met FDA requirements, that the liver enzyme elevations observed during testing had been within normal variation ranges and didn't predict the severe reactions that some patients later experienced, that Veritas had acted responsibly by reporting adverse events and ultimately pulling the drug from the market when safety concerns became clear. Price characterized the plaintiff's claims as hindsight bias, the tendency to look at a negative outcome and assume it should have been predictable, when in reality medical science involves unavoidable uncertainty and risk. He told the jury that glucosamine had helped thousands of patients control their diabetes, and that the benefits had outweighed the risks for the vast majority of users. The severe reactions experienced by some patients were tragic, but they didn't mean Veritas had done anything wrong. The trial proceeded methodically over the next 3 weeks. We called Dr. Ross, the Veritas toxicologist, as a witness. She testified about her concerns regarding liver toxicity and the pressure she had faced to minimize those concerns during the FDA approval process. Price cross-examined her aggressively, suggesting that her concerns had been speculative and that she had misinterpreted preliminary data. We called Dr. Martinez and James Chen, the former Veritas employees who had resigned over safety concerns. They testified about the culture of minimizing adverse events and prioritizing business considerations over patient safety. Price suggested they were disgruntled former employees seeking to damage their former employer's reputation. We called medical experts who explained the mechanism by which glucosamine caused liver and kidney damage. They testified that the damage was not a rare, unpredictable reaction, but a dose-dependent toxic effect that should have been identified during proper clinical testing. Veritas called their own medical experts who disputed our experts' conclusions. They testified that the liver damage could have been caused by other factors and that glucamine's role was not definitively established in most cases. We called several of our clients to testify about their experiences. Robert Davidson described what it was like to wait for a liver transplant, not knowing if he would die before a donor organ became available. Jennifer Park described the impact of kidney failure on her daily life and her sense of identity. Michael Chen described watching his father die and learning that the medication he had trusted had been the cause. Price cross-examined them sympathetically, but tried to establish that their doctors had properly monitored them and that they had been informed of potential side effects. The most critical moment of the trial came when we introduced Dr. Brennan's email, the one where he had written that they couldn't let perfect be the enemy of profitable. Tom read the email aloud to the jury. Then he asked our pharmaceutical development expert to explain what that statement meant. The expert testified that the statement showed a fundamental prioritization of profit over safety, that a responsible pharmaceutical company would delay a product launch if there were unresolved safety questions, regardless of the financial impact. That Dr. Brennan's statement revealed a corporate culture where business considerations trumped patient welfare. Price objected repeatedly, arguing that we were taking the email out of context and that Dr. Brennan had been referring normal business considerations that every company balances against regulatory compliance. But the damage was done. The jury had heard, in the CEO's own words, that Veritas had been more concerned about profits than about whether their drug was safe. Veritas chose not to put Dr. Brennan on the stand. Price said it was because Dr. Brennan's testimony would be cumulative. His company's position had already been explained by other witnesses, but everyone in the courtroom understood the real reason. Brennan couldn't take the stand without being forced to defend his email and his decision-making process, and no amount of preparation could make that testimony anything other than devastating. The trial concluded with closing arguments.
Tom's closing was powerful. He reminded the jury of the evidence showing that Veritas had known about safety risks and had concealed them. He showed them the timeline of adverse event reports and Veritas's inadequate response. He asked them to send a message that companies cannot put profits over patient safety and expect to escape accountability.
Price's closing emphasized the difficulty of pharmaceutical development and the impossibility of footing every potential adverse reaction. He asked the jury to consider how many patients had benefited from glucosamine and to remember that medical progress always involves some degree of risk. The jury deliberated for 6 hours. When they returned, the foreperson announced that they had reached a verdict on all counts. Judge Morrison asked them to announce their findings. The jury found in favor of the plaintiffs on negligence. Veritas had failed to conduct adequate safety testing and had failed to properly warn patients and doctors about known risks. The jury found in favor of the plaintiffs on fraud. Veritas had knowingly concealed material safety information from the FDA and from patients. The jury found in favor of the plaintiffs on willful misconduct. Veritas had acted with conscious disregard for patient safety. The compensatory damages were substantial, covering medical expenses, lost wages, pain and suffering for every affected patient. The total compensatory award was $112 million. Then Judge Morrison asked the jury to announce their punitive damages award. The foreperson said that the jury had carefully considered what punitive damages would be appropriate to punish Veritas's conduct and deter similar behavior by other pharmaceutical companies. They had awarded $340 million in punitive damages.
The courtroom erupted. Some of our clients were crying with relief. Others were hugging their family members. Several reporters rushed out to file their stories.
I stood next to Tom, feeling a mixture of exhaustion and satisfaction. We had done it. We had held a pharmaceutical company accountable for putting profits over patient safety. We had secured compensation for patients who had been harmed. We had sent a message that this kind of corporate behavior would not be tolerated.
Judge Morrison gavelled the courtroom back to order and thanked the jury for their service. She scheduled a hearing for the following week to address post-trial motions and finalize the judgment.
After the verdict, I held a press conference on the courthouse steps. Reporters asked about the case, the evidence, the significance of the punitive damages award. One reporter asked about the earlier controversy involving Judge Whitfield's refusal to recuse himself. I said that I was grateful the case had been tried before Judge Morrison, who had presided with the fairness and impartiality that every litigant deserves. I said the case had never been about my stepfather or about judicial ethics. It had been about 12,000 patients who deserved accountability from a company that had betrayed their trust. I didn't mention Richard's pattern of favorable rulings for donors. I didn't discuss the ethics investigation or the reprimand. I didn't need to.
The public record spoke for itself.
The following week, I was promoted to partner at Brennan & Cole. The firm's management committee voted unanimously, citing my handling of the Veritas case and my commitment to ethical practice even under difficult personal circumstances. Tom called me into his office to deliver the news personally. He told me that the firm was proud of the way I had handled both the case and the recusal controversy, that I had demonstrated the kind of integrity the firm valued above all else. I thanked him and said that I had only done what was necessary. He smiled and said that doing what's necessary, even when it's difficult, was the definition of good lawyering. I called my mother to tell her about the promotion. She congratulated me, her voice tight with an emotion I couldn't quite identify. Pride, maybe, or guilt, or some complicated mixture of both. I asked how Richard was doing. There was a long pause.
He's been under a lot of stress, she finally said. The investigation, the media coverage, the cases he's had to recuse himself from. It's been difficult for him.
I expressed sympathy, though I'm not sure I meant it. My mother said they were considering taking a trip, getting away from Seattle for a while, maybe Europe, somewhere Richard could relax and forget about the past few months. I told her that sounded nice and that I hoped the trip would help. We talked for a few more minutes about inconsequential things, her garden, my apartment, the weather. Then she said she needed to go and hung up. I didn't hear from her again until September. The call came on a Tuesday afternoon in mid-September. I was in my office reviewing a new case when my phone rang. Mom calling. I answered. Hi, Mom. Her voice was different, smaller, uncertain. She said she and Richard were separating. I set down the brief I had been reading. What happened? I asked. My mother took a breath. She said she couldn't do it anymore. Couldn't pretend that Richard's behavior had been acceptable. Couldn't defend his decisions to friends who asked uncomfortable questions. Couldn't live with a man who had valued his professional reputation over basic ethical principles. The final straw had been a conversation they'd had the previous week. Richard had insisted, once again, that he had done nothing wrong, that the Judicial Council had overreacted, that the entire scandal had been manufactured by hostile attorneys and overzealous reporters looking for a story. He had blamed me, my mother said quietly, told me that if you had just accepted his authority and proceeded with the case without making a fuss, none of this would have happened. Said you had damaged his career out of spite because he wouldn't invite you to his New Year's party. I was quiet, processing this. My mother continued. She said she had asked Richard if he really believed If he truly thought I had filed a recusal motion and escalated to the Court of Appeals and exposed his pattern of donor favoritism, all because I was angry about a party invitation. Richard had said that plaintiff attorneys like me were vindictive by nature and that I had probably seen the case assignment as an opportunity to embarrass him publicly. I asked what my mother had said in response. Her voice cracked. I told him he was wrong, that you had done the right thing, that he should have recused himself the moment he saw your name on the docket, that his refusal had been arrogant and foolish and had damaged his career far more than any recusal motion ever could. We were quiet for a moment. Then she apologized. She apologized for choosing Richard over me at Thanksgiving and New Year's Eve, for allowing him to make her feel ashamed of my work, for not standing up for me when it mattered, for believing his characterization of plaintiff attorneys instead of trusting her own daughter's integrity. I told her I understood, that she had been trying to support her husband and maintain her marriage, that I didn't blame her for wanting to believe in him. But I also told her that I was glad she had finally seen who he really was. My mother asked if we could have lunch sometime, start rebuilding the relationship that Richard had damaged. I said yes. We met the following week at a quiet restaurant downtown. We talked for 3 hours about my father, about her marriage to Richard, about the choices she'd made and the ones she regretted. She asked about the Veritas case, and I told her about the clients I had represented. Robert Davidson, waiting for a liver transplant. Jennifer Park, dealing with kidney failure. Michael Chen, whose father had died because a pharmaceutical company had decided that some number of dead patients was an acceptable cost of higher profits. My mother listened, really listened, in a way she hadn't in over a year. She said she was proud of me, proud of the work I did, proud that I had stood up to Richard when it would have been easier to back down and accept his authority. I told her that standing up to him had never been about revenge or spite. It had been about doing the right thing, even when the right thing was personally difficult. That's what integrity means, I said. Not doing the right thing when it's easy, doing it when it's hard, when it costs you something, when people you care about might judge you for it. My mother nodded, tears in her eyes. We met for lunch again 2 weeks later, and 2 weeks after that, slowly, carefully, we began rebuilding the relationship that Richard's presence had fractured. Richard, meanwhile, faded from public prominence. The ethics reprimand remained on his record, a permanent mark that would appear in any database search of his judicial history. His docket remained thin, populated by minor cases that didn't require specialized expertise or involve parties with political connections. The colleagues who had once sought his company at professional gatherings now kept their distance, unwilling to be associated with a judge whose impartiality had been publicly questioned. Judge Chen, who had toasted Richard at that New Year's Eve party, stopped returning his calls. Judge Stinson, who had been a regular at Richard's social events, made excuses when Richard invited her to dinner. Richard tried to rebuild his reputation through careful, methodical work on the cases he was allowed to hear. He wrote detailed opinions, cited extensive precedent, and made sure his reasoning was beyond reproach. But the damage was done. Once a judge's integrity is called into question, it's nearly impossible to fully public confidence. Every ruling Richard made was scrutinized for signs of bias. Every decision in favor of a defendant was analyzed to see if there was any connection between that defendant and Richard's former life as a corporate defense attorney. I heard through legal circles that Richard was considering early retirement, that he had grown tired of the scrutiny and the restrictions on his caseload, that he missed the days when he had been respected and influential before a single recusal motion had exposed the ethical compromises that had defined his career. I felt no satisfaction in his downfall, only a kind of sadness that it had been necessary. Richard Whitfield could have been a good judge. He had the legal knowledge, the experience, the intellect, but he had never understood that being a good judge required more than just legal expertise. It required integrity. It required the willingness to set aside personal relationships and political connections in service of impartial justice. He had failed that test, and the consequences had been severe and permanent. 6 months after my mother's call about the separation, Richard announced his retirement from the federal bench. The press release cited a desire to spend more time with family and pursue other interests, but everyone in the legal community understood what it really meant.
He was leaving before the scrutiny became unbearable, before another case raised questions about his impartiality, before his colleagues' polite distance turned into open rejection.
The Judicial Conference accepted his retirement with a brief, formal statement thanking him for his service. There was no ceremony, no celebration, no gathering of colleagues to toast his career. Just a quiet exit from a position he had compromised through years of small ethical lapses that had accumulated into an undeniable pattern. My mother attended Richard's retirement dinner, a small affair at an expensive restaurant with fewer than a dozen guests. She told me later that Richard had seemed diminished, smaller somehow without the trappings of judicial authority to prop up his self-image. She had felt sorry for him, she said, but she hadn't regretted leaving. The divorce was finalized in the spring. My mother moved into a smaller house closer to downtown Seattle. She started volunteering at a legal aid clinic, helping low-income residents with housing disputes and consumer protection issues. She told me that working at the clinic had given her perspective, that she finally understood what I did and why it mattered, that seeing people who couldn't afford lawyers struggle against corporations and landlords had made her realize that access to justice wasn't just an abstract concept. It was the difference between families keeping their homes and ending up on the street. As for me, I continued doing the work I had always done. I took on new cases representing clients who had been harmed by corporate negligence, medical malpractice, defective products. I won some cases and lost others, but I approached each one with the same commitment to ethical practice that had guided me through the Veritas litigation. I mentored younger attorneys at the firm, teaching them the importance of integrity and principled advocacy. I told them about the Veritas case, about the recusal controversy, about the choice I had made to prioritize ethics over family harmony.
Some of them asked if I regretted filing the recusal motion, if I wished I had just accepted Richard's authority and avoided the public conflict.
I told them no, that the recusal motion hadn't been about Richard personally. It had been about ensuring that my clients received a fair trial before an impartial judge, that their cases were decided on the merits of the evidence rather than the judge's personal relationship. That's the job, I would tell them. Advocating for your clients even when it's uncomfortable, even when it costs you something personally, even when it would be easier to stay quiet and go along. The following December, as New Year's Eve approached again, I thought about that phone call from my mother a year earlier, the uninvitation to Richard's party, the subtle message that I wasn't good enough for his professional circles. This year, I was hosting a New Year's Eve gathering of my own. Nothing elaborate, just friends, colleagues, people I respected and enjoyed spending time with. My mother asked if she could attend. I told her I would love to have her there.
On New Year's Eve, my apartment was filled with laughter and conversation. My colleagues from the firm, friends from law school, clients who had become friends after their cases concluded.
Robert Davidson was there, healthy now, after his liver transplant, back to working and living a normal life. Jennifer Park came, still dealing with kidney issues, but doing better than she had been during the trial. Michael Chen attended, and we toasted his father's memory. My mother arrived early, bringing champagne and a nervous smile. She met my friends, heard stories about cases I had worked on, listened to my colleagues talk about the difference our work made in people's lives. At one point, she pulled me aside. "I'm sorry I ever made you feel like this work wasn't important," she said quietly. "I'm sorry I didn't see what you were building. I'm sorry I let Richard convince me that prestige mattered more than principle." I hugged her. "It's okay, Mom. You see it now. That's what matters." At midnight, we counted down together. When the clock struck 12, everyone raised their glasses. "To justice," someone called out. "To integrity," someone else added. "To doing the right thing even when it's hard," Tom said, looking at me. "To family," my mother said, her eyes on mine. We drank, and the new year began.
Richard Whitfield was not there. He was not invited. He was not discussed. And for the first time in a long time, his absence felt like exactly what it was: irrelevant. Because the truth is, people like Richard derive their power from the belief that their approval matters,
that there are professional circles and their prestigious connections are worth sacrificing your principles to access. But once he realized that integrity is worth more than access, that doing the right thing is more valuable than being included in the right rooms, their power evaporates. Richard had tried to make me feel small, to suggest that my work was embarrassing, that my presence would diminish his reputation, that my professional choices made me unworthy of inclusion in his world. Instead, I had shown that his reputation was built on compromises that couldn't withstand scrutiny, that his prestigious position was vulnerable to the very ethical standards he had sworn to uphold, that his world of elite connections and social climbing was fragile when confronted with basic principles of judicial impartiality. I didn't destroy Richard Whitfield's career. He did that himself through years of small ethical compromises that accumulated into a pattern of bias that could not be ignored once it was exposed. All I did was refuse to be complicit in it, refuse to accept that family loyalty meant turning a blind eye to judicial misconduct, refuse to believe that my career was less valuable than his comfort. And that, I think, is what real justice looks like sometimes. Not dramatic courtroom confrontations or explosive revelations.
Just the quiet, steady insistence that the rules apply to everyone. That power doesn't exempt you from accountability. That integrity matters more than influence.
Richard learned that lesson the hard way, but he learned it. And in the end, that might be the most important thing. Looking back now, several years after all of this happened, I can see the full arc of what transpired. Richard's retirement from the bench was just the beginning of his fade from relevance. He tried to return to private practice, but no major law firm would hire him. The ethics reprimand and the circumstances of his departure from the bench made him damaged goods in a profession where reputation is everything. He eventually opened a small solo practice focusing on business consultations and contract reviews. Nothing like the high-stakes corporate defense work he had done before his judicial appointment. Nothing that would restore his sense of importance or influence. My mother told me that Richard had become bitter, that he blamed me, blamed the media, blamed the Judicial Council, blamed everyone except himself for the choices that had led to his downfall. She said she had made the right decision to leave, that living with someone who refused to accept responsibility for his own actions was exhausting and ultimately corrosive.
The Veritas case, meanwhile, had lasting impact beyond the verdict.
The $340 million punitive damages award sent shockwaves through the pharmaceutical industry. Other companies conducting clinical trials began implementing more rigorous safety monitoring protocols. The FDA announced new guidance requiring enhanced disclosure of potential safety signals during the approval process. Several of the internal documents we had introduced at trial became case studies in law schools and medical ethics programs, examples of what happens when corporate profit motives override patient safety. Robert Davidson used his settlement to pay off medical debt and establish a foundation supporting liver transplant patients. Jennifer Park became an advocate for kidney disease awareness. Michael Chen created a scholarship in his father's name for students studying pharmacology and drug safety. The case changed their lives in ways that went beyond financial compensation. It gave them validation, acknowledgement that what happened to them mattered, that the system could sometimes work to hold powerful corporations accountable. As for me, I continued building the career that Richard had once dismissed. I was named one of the top plaintiff attorneys in Washington state. I won several more significant cases. I mentored younger lawyers and taught them that ethical practice and successful practice weren't contradictory, that integrity was actually the foundation of long-term success. And every New Year's Eve, I hosted a gathering of people who understood that success measured by integrity is more valuable than success measured by prestige. My mother never missed one. Neither did many of the clients whose cases I had handled over the years. It became a tradition, a celebration, not just of a new year, but of the principle that doing the right thing, even when it's difficult, is always worth it. This story is a reminder that sometimes the most powerful form of justice isn't destruction or revenge. It's simply refusing to compromise your principles for someone else's comfort. It's insisting that the system work the way it's supposed to, even when powerful people want exceptions. It's standing up for what's right, even when it costs you relationships and access and approval. Because in the end, integrity is the only thing you truly own. And no one, not a federal judge, not a stepfather, not anyone, can take that from you unless you give it away. Richard Whitfield tried to make me choose between my principles and my family. I chose my principles, and eventually my family chose them too. That's not revenge, that's justice. And justice, when it's real, doesn't need to be loud or dramatic. It just needs to be brew.